Good evening, everybody. As Terry said, I do a fair bit of speaking around Canada, North America, and some international travel as well. So I do spend more than my share of time in planes, trains, and automobiles. Generally not with John Candy. Usually I do that with somebody else. Is anybody here planning a trip anywhere in the near future? Flying anywhere? Okay, I'm just here to tell you I do a lot of flying with Air Canada. And if you haven't flown with Air Canada lately, I'm here to reassure you that they are living up to their motto. We're not happy until you're not happy. I was on a flight out west a couple of months ago, and there was a fair bit of turbulence. Going through in British Columbia, there was a fair bit of turbulence on the plane. They said, we may have some rough spots during the flight, but relax. And if we're in the middle of service and we have to suspend service, and I'm thinking this is a service as in drinks, not as like a priest drink. I say, so is that kind of service? Then we'll get back to you as soon as we can. I said, okay, fine. So the plane is still. We've been in the air now about 20 minutes or so, and the captain gets on the intercom and says, "This is Captain Steve McDonald. Welcome you to Flight 397, bound for Prince George. The air looks pretty good up ahead. We think that we'll be arriving on time at our destination in Prince George. The weather there is also very good, about 13 degrees centigrade. We'll soon be hitting our cruising altitude of about 32,000 feet. And at that time, he screams, the plane's going like this, and people are screaming, the overhead luggage is falling out, and people are pulling out their rosaries and yelling. I don't know how far we dropped. We dropped a lot. I'm thinking maybe 5,000 feet or whatever in a few seconds. And the plane then stabilizes, and people are still really worried. The flight attendants are running up and down, making sure everyone's okay. And everyone's settled down now, and then the captain gets back on the intercom and said, this is the captain speaking again. I'm very, very sorry about that. The plane is in good shape. No mechanical difficulties whatsoever. We'll be okay again. We'll have to you'll have to remain in your seats for the time being until we get back to that cruising altitude. It's just that as I was going through my opening announcements, the co-pilot handed me a cup of coffee and he spilled it right in my lap. You should see the front of my pants. Guy in the back of the plane yells out, "Hey buddy, you should see the back of mine." Variously, when I speak to client groups or advisor groups, I get accused of doing what that pilot did, scaring people. That's not really my purpose now, but certainly it is to provide you some meaningful information today, hopefully some transferable ideas. And yes, if you get a little nervous, that's okay. Most groups do get a little nervous from time to time when they get through certain conversations. If you have any questions, feel free to stop me at any point in time and ask me a question. I'm reminded of the story of the grandfather who's taking out his 7-year-old grandson fishing for the first time. Summer holidays have just started. The grandson, Nicky, had just had a birthday at the end of June, and Grandpa forgot that gift, and his birthday was coming up so quickly. Stops by at Walmart, buys a $29.95, fishing kit with pictures of blue marlin on it, and Nicky thinks that's what they're going to go fishing for out in the lake. And so Grandfather says, look, there are some rules about going fishing. First off, we've got to get up really, really early in the morning. So you have to be quiet, really quiet. Got to go to bed early, be really quiet, can't wake up anybody in the house. And so we'll make our lunch now, and we'll do that together, whatever you want to eat, and drinks and that sort of thing. We had it all packed up. Go to bed, and I'll wake you up about 5:30 in the morning. That fishing is really good around 6 o'clock in the morning. Now you have to be really quiet. Remember, quiet, not just inside the cottage here. We have to be really quiet on the lake because your voice carries right across the whole lake. You'll start waking up everybody, and all the neighbors will get upset, and you'll scare away the fish, and we won't catch anything. Nicky says, okay, Grandpa, I'll remember to be very, very quiet, very quiet. And I know we're going to catch a really huge fish because you got me this brand new kit. And look at the fish we can catch with this thing. And he pointed to the blue marlin, the big 50-pound salmon, pictures on the little Walmart fishing gear. He says, well, Grandpa, he says, Nicky, we'll have a good time. We're going to have a good time. We'll catch something. Well, they're out in that water for about 4 or 5 minutes, and Nicky's tugging at his grandfather's sleeve, and he says, Grandpa, can I ask you a question? And Grandpa says, sure, Nicky, what is it? And he said, how do fish breathe underwater? Grandpa says, I have no idea. I don't know that. But we'll look that up on the internet when we get back later on today. See? Shh, shh, shh. A couple minutes later, Nicky says, Grandpa, how is it that those huge ships in the ocean float? I mean, they win thousands and thousands of pounds of steel, heavy iron, full of people and stuff. How can they float? And Grandpa says, that's a really good question, Nicky. I don't know the answer to that, but watch your line over there, okay? Watch your line. A couple minutes later, Nicky asks another question, Grandpa, why is the sky blue? Grandpa says, I don't know, Nicky, but we'll look it up when we get back. And Nicky says, gee, Grandpa, is it okay if I ask you these questions? And Grandpa says, you ask all the questions you want, because if you don't ask any questions, you'll never learn anything. I'll just let that sink in for a bit, and then you'll figure out this. So if you have any questions, please ask them. I can't promise that I will be able to answer all of your questions, but I will promise to get back to you if I can't answer them this evening, and get back either to you or through someone here at the agency, and they'll get back to you in a timely manner. You know, we see a lot of the same types of mistakes being made over and over again by people who either fail to plan properly or use do-it-yourself methods of getting things done. And they do that to save money. They do that because they're in a hurry. They do that because they've been putting it off for a long time. Now they're going on a big trip and said, Jesus, God forbid something goes wrong. And so now they're panicking. They want to get something done. In either case, money isn't saved. Time really isn't saved either, because you've got to go do that over again at some point in time. The process generally takes a lot more time than you initially thought. It takes much more effort, much more money, sometimes a lot more money when you look at the payback, because someone has to implement some of these plans and said, I didn't do that as efficiently as I could. And what's more, most people go through this exercise only once. And what I have found in life is that things you do once, you're not likely to do very well if you only do it once. People do this all the time, learn from their mistakes, they learn, they gather things up, it becomes intuitive, but if you only do it once, you're not likely to do it particularly well. And this is something people do generally once. And I think that's why it's important for you to sit down with people's organizations like this thing to help you get it right the first time, or as much of it right as possible the first time. And then what I say as well, to periodically stress test the plans and solutions to make sure that those plans and solutions continue to do the job they were designed to do when you first set them up. So who's been on a cruise? Show of hands. Keep your hands up if you've been on more than one. Okay. So for all you regular cruisers, and I mean ship cruisers, there's an exercise you have to go through generally before the ship leaves the dock. Can you tell me what that is?
Oh, we have to do the lifeguard?
Lifeboat drill, right?
Yeah.
You got to put on that silly, uncomfortable life jacket. You can't carry it in your arm. You got to put it on, and you have to go to your station, right?
Sometimes. Not all cruises did it.
Not all cruises did it. Yeah, I know the Concordia didn't do that, but you know what happened there, right? That's the problem, because they didn't do it. And they didn't even do it properly at the time the ship was actually going down. So that can be a little problematic. So typically, though, with most cruises, most responsible cruises, you go through that exercise. Now, you've been on 3 or 4 of these, right?
About 6.
6. Do they give you a little tag, a little pass card, and said, look, you've been on this 4 or 5 times. Why don't you just go to the bar, have yourself a drink. We'll catch up with you later.
No, they haven't done that yet.
No. Usually, you may go through the exercise. And in fact, if you're one of the first people there, if Edward's one of the first people there, they'll say, Edward, you're looking in pretty good shape. Here's the deal.
Need you glasses?
Yeah, I've got glasses. I got to clean them maybe. But so they'll say, well, look, if I'm not here, Edward, you pay particular attention. Everybody listening? Because if I'm not here, you're in charge.
Oops.
And then they go through the exercise. They go through the drill, right? Why do they do that before the ship leaves the dock?
Just in case you have to abandon the ship.
In case you have to abandon the ship. But why before the ship leaves the dock?
Because the boat can sink right there.
Yeah, maybe. You've got a captive audience. Everyone's together. Any other reasons?
It's too late if you don't.
Yeah, you see, if something goes wrong during the drill, you're on shore, you can get it fixed. You can get the parts, you can get right there on shore, you can get it done. That's one of the big reasons why you do it then. There's another reason why you do it while the ship is still at the dock. And the other big reason is that if you don't want to participate, Edward, you haven't been to your room yet, have you? You haven't seen your bags since you went through. We take you and your bags, we put them on the dock, pull out your camera, hand it to you and say, take a picture of your family and friends as they're drifting off in the sunset because you're the liability. That's what they do it that way, right? Right? They stress test the plan to make sure it works, and if something goes wrong, you've got the opportunity to fix it right now before something does go wrong in the middle of the ocean. And it makes sense, if it makes sense to do that when you're getting on a ship, you've got to do that exercise no matter how many times you fly in an airplane. You work in a commercial building or in a school, fire drills are, you got to do it, right? Doesn't it make sense to go through a fire drill with the plans and solutions you put in place for your life to make sure not only do they work when you set them up, but that they continue to work down the road, and if they don't, you can actually fix them. That make sense? Yeah? Anybody here got fire extinguishers? You got some fire extinguishers? Somebody else in the room? Okay. You got fire extinguishers. You got the good kind with the gauges on it. You got 3 or 4 different kinds. You know there's different kinds for different kinds of, you know all that, right? Do they work?
Well, you know what? I haven't tried them.
It's a very honest question, Nancy.
Yeah.
You don't know if they work. Now, how long have you had them, some of these things?
I just bought a new one.
Just bought a new one.
Because the pressure expired on the old
The
one.
pressure expired, yeah. But you don't know if it actually works. Now, you don't know there's different kinds. Some people don't know there's different kinds of fire extinguishers that do different sorts of things, right? You could have a fire extinguisher, by the way, you know, the fancy ones with the big gauge that says green. Okay, well, that's fully charged. That'll work. Have you ever been in a car, your own car? You're driving around downtown London for about 10 or 15 minutes, and you got to go, I don't know, to the south side, full tank of gas when you left. You've been in that car like 20 minutes, you got half a tank of gas gone. Ever happened to anybody? Sticky gauge or gas, it just drops like this. Is that, what happened there? Sticky gauge. Could that happen to that fire extinguisher you got? That was, you know it went, but it could be green. The thing can have no power in it whatsoever. That could happen, right?
Stuff happens.
I know it happens. But you got to stress test these things, because every now and again you can take these ones with the gauges and have them tested out and do that, right? So people like this and Terry and other people these guys are your fire department. They're the inspectors that come around and said, you know what, that gauge is not working, let's top this up, let's test this thing out. And one of the biggest issues, first and last, is that either we're talking about legacy planning, there is no plan, or if there is a plan, it hasn't been stress tested lately to make sure that the plans and solutions attached to them continue to do the job they were designed to do when you first set them up. And that could happen for a number of reasons. Now, it's called common estate planning mistakes. I generally call them common legacy planning mistakes, because what I have found over the years in talking to august bodies like yourselves over the years is that many people really aren't concerned. First off, it's boring to talk about estate planning, and secondly, that's the stuff that happens after I'm gone. And besides which, I'm not really planning on leaving much of an estate to anybody else. You know, I built my company, my business for me and for my partner in life. I didn't do this for my whole life so that I could give it all away to my kids and grandkids. Well, maybe my grandkids, but not my kids. You know, if I'd known grandkids were this much fun, I would have had them first, right? You always look at that order. Right? But charity starts at home, and it starts with me. It's my money, and I want to do that. So, but leaving a legacy is something that resonates with a lot of people. So even though I only look like I'm 26 years old, I am a baby boomer. And we're the generation that started Greenpeace. That was us. So we get accused of polluting the world, but we're the people that actually started this whole thing about green this and green that, whatever else said that. And we're the people that 18 and 19 and 21 would walk around placards and say, drop acid, not the bomb. Don't trust anyone over 30. Like, that was us, right? We protest on just about everything. Everything we would protest, votes, that sort of thing. And then, of course, we grew up, externally anyway. We got jobs, and we became doctors and dentists and accountants and business people and financial services executives and all that kind of stuff. And a lot of people don't think, well, they don't associate who we were, and they'll know the picture when you were in university and high school, the long hair and the beads and the patches on the knees and flower children, with who we are right now. And yet, if you think about people like Bill Gates, who's also a baby boomer, Bill started a foundation, a club actually, a few years back, that you can join as long as you've got $500 million of assets and you sign a piece of paper promising you're going to give it 90% of it away before you die within a certain period of time. Keeping up with the Joneses now has nothing to do with whether you drive a nicer car or live in a nicer house or whatever else like that. It's about making a difference. It's about giving back. It's about being remembered. It's about leaving a legacy. And that resonates with a lot of people. Because you look now and you say, you know what? When I was 18 and 21, I had no money. No one respected me. Now I'm 50, or I'm 55, or I'm 60. And deep down inside, I'm still that person that I was when I was 21 years of age, in some respects. Only now, people look up to me. If I want to get something done, I know who to call. In some cases, I'm the people other people should be calling to get things done, to make that difference. So that dash between the lines actually means something. So leaving a legacy becomes very, very important to people. And not just a legacy about later, a legacy now. Think of the Bill Gates Club. It's about the legacy you want to leave while you're alive, not just after you pass away. So when we're talking about legacy planning mistakes, even though I'll focus about the stuff that happens after you're away, I want you to think a little bit more broader than that and talk about legacy planning mistakes and issues and opportunities about the things you actually want to do for other people, the legacies you want to leave while you're alive and after you pass away. So I'll be covering off some things about wills, integration, some of the issues with integration, liquidity and debt issues, the difference between what I would call an equal versus a fair distribution when you're looking at legacy planning in the States, the unfettered use of joint tenancies, documentation and planning, and of course, if you have any particular questions or issues, be sure to stick up your hands and ask your questions. I'll start off really, really light, really, really easy with something like the last will and testament. You know, in Canada, there are basically three types of wills. I would say in Canada there are four. Quebec has their own, so in common law provinces there are really three types of wills that are available. The formal will, a notarial will if you're in Quebec, a holographic will, and that's not Star Trek stuff where you see a picture of somebody but they're actually someplace else. I mean, I'll go into that in a second here. And this whole issue of something on printed stationery forms or via forms on the internet. I don't know if everyone here has a will. I'm not going to embarrass everybody by asking for a show of hands or whatever else like that. I do know that statistically, a lot of people don't. I know statistically that of those that do, they said, have you got a will? Of course I've got a will. Of course I've got a will. I took care of that will. I took care of that 20 years ago. Really? Yep, 20 years ago. I said, that's great, Barbara, 20 years ago. And who did you name as your executor for your will? And you say, well, Adam, my brother Adam, who, he died 3 years ago. I guess I should go around and change that at some point in time. Yeah, I made the will up and I had an issue I didn't have any issues with my kids at that point in time, and so of the part of my estate that I didn't get to spend, I thought I'd leave that to the kids, most of it to the kids anyway. They were great when they were in their early 20s and early 30s. One's in a really terrible marriage right now. The other one's developed some alcohol and drug dependencies, and the will has just said, give them the money. And I'm not sure that's a smart idea with both of my kids at this stage in their lives, because stuff changed and things happened. So maybe I got to change my will, maybe I got to change a couple of other things as well, with some of those things. It's interesting how when I talk about the fact that people panic, it's not unusual to have people say, well, I got that will, it was 20 years ago, and you're going on a big trip tomorrow or next week, and so you quickly draft something together. Maybe this will be okay. Oh, I'll go get a witness, and I'll go get the neighbors. I think you got to do that kind of stuff. A couple things you have to remember about wills is that no one's saying that one is actually better than the other. The formal will, the holographic will, printed stationery forms, they're all valid wills. I mean, as of this year, you can go to Walmart now in Canada, and you get a will drawn up for $99. I'm not sure what section of the store that's going to be in, but they made a deal now with a law firm where you don't want to spend the money, spend a lot of time. It's a very simple situation. You can get your will done for $99. So it doesn't have to cost you a lot of money. I'm not even suggesting that everyone needs a will. I used to think everyone needed a will. And then 3 years ago, I was invited off to see a client with an advisor, and we sat down and talked about a situation, what he believed in, what he valued, and I found out this individual believed in reincarnation. So in his will, he left everything to himself. There wasn't really a lot I could do for him after the fact, but most people aren't in that type of a situation. The issue really is, and where the issues and the challenge work off, is that the devil is always in the details in terms of what you do and what you don't do. Going to a lawyer and getting a will drawn up doesn't mean it's necessarily drawn up properly. It doesn't mean that it's complete. It doesn't mean that everything's included. But typically, that's probably the best way to go. It's probably the way that most of you have gone already, and most of you go in the future. A holographic will is something that is valid in Ontario. It's completely handwritten, totally handwritten, with witnesses. And of course, the witnesses are better. Witnesses, by the way, can't be anyone that's going to get anything out of the will. The witnesses have to be in the same room at the same time when they're witnessing signatures. Like those sorts of little details that people don't do. They get the will drawn up. They walk 3 doors down the street and talk to the neighbor who's out cleaning his cars. And they say, you got a couple minutes here? Just did up a wills here. Just need a quick signature. He signs it. He didn't say you sign it. You just sign it right now. And then the next day, 2 days later, you get another neighbor, a friend, neighbor. Maybe you get your son, someone to sign that will. That will's not valid. Is that going to be an issue? It could be. It could be a big issue, and I'll go into some of the issues down the road. There's nothing wrong, I suppose inherently wrong, with getting one done that's on printed stationery forms or via the internet. The internet's got some great information. Doesn't necessarily mean it's accurate. Just because it's on the internet doesn't mean it's true. But you can do that as long as you follow all the guidelines precisely. And as long as you are comfortable that where you sign that will, and that where you are right now is where you're going to be when someone has to read it. Because the will has to be not only valid in this jurisdiction, the will better be valid in the jurisdiction where you are when someone grabs you and says, come up and join me in heaven or wherever, and we'll be doing that reading. It has to be valid in that jurisdiction, not just this jurisdiction. So if you've got plans to say, you know what, I'm going to retire in British Columbia, great, have a nice time. Is the will you drew up here going to be valid there? I spent 4 to 6 months down in Florida. Great, not a problem. Is the will you up here going to be valid in Florida? Is the will you got up here not only going to be valid in Florida, will it actually cover adequately the property you own down in Florida or in Arizona? Have you stress tested that to make sure it's actually going to work? Let alone deal with the ugly little details about funding it in cash and what gets taxed and what doesn't get taxed. So again, formal will, typed, signed by the testator, at least 2 witnesses who cannot be beneficiaries or spouses of the beneficiaries. They've got to be present at the same point in time. Notarial wills are only available in Quebec. I say that because maybe there's somebody in this room that is in Quebec. Maybe you've got family that's in Quebec. Maybe you say, you know what, I've covered all this off, Peter. This is pretty basic stuff. And he said, that's okay for you. What about your family? And it's your relatives, your kids, your grandkids, your parents. Because a lot of us still have parents that are quite alive, notwithstanding how old we may be getting. How many people have parents that are still living? Lots, lots. 50 years ago, the average 50-year-old individual in Canada had 1 surviving parent. Today, in Canada, in the United States, 12,500 people turn 50 every single day. As part of a 20-year trend. And most of them have 3 surviving parents. 12,500 people turning 50 every single day, average they got 3 surviving parents. And if you're in your late 30-something, 40-something, 50-something, almost half of people right now in that age bracket around 50 have already been a caregiver for somebody, they've done it already, are a caregiver right now, and I know that's the case in our household, or know that they will be in the very near future. What is that going to do to your legacy plan, and how comfortable are you with the legacy plan that someone else has put together or not put together that's going to impact your plans for your lifestyle and everything else? Because that average 50-year-old individual today, most of them will be women. 80% of the caregiving is given by women. The average 50-year-old woman today will spend more time in her lifetime taking care of her parents than she ever did taking care of children. Think about that. More time in your lifetime taking care of parents than you ever did taking care of children. Now, the fact of the matter is that the average 50-year-old woman today will have more husbands than children. That's also true. I said that in a conference a couple weeks ago, and a lady yelled out, "What's the difference?" Couldn't answer that question. Terry.
Peter, you've drawn on a really good point, and there were two recent cases that we had within the last 5 years I wanted to point out. One was in Ontario, getting married invalidates your will, unless the will is made in contemplation of the marriage. So we had parents that had divorced and remarried, but did not redo the will, and one of them dies. And so they died in what's called intestate. There was no will. So then you fall under intestate law.
Which I'll go through in a minute, yeah.
I won't say what they are, but they're quite a bit different than what was intended underneath the will. So that's one thing that's, very often not caught. The other part is if the will is holograph, remember that anybody can change their estates at the very last minute. So one of the cases we had was the fellow, the family had broken up and separated, and he actually committed suicide. But before he did, he wrote a holograph will, leaving all his life insurance proceeds and half of the family house and family business to the new girlfriend that he had gotten over the last couple of months. And so these types of things tend to happen. Like what you say, you can't emphasize it enough as to what you should be looking at, not only at your own will, but your parents' wills.
Yeah.
And even that of your children, if you have those kinds of conversations with them.
So in Canada, can you have two spouses?
Yes.
And the answer is yes, you can. You can have two spouses. Each could have valid claims to your stuff. And have you made provisions to make sure that you only have one, or if you had two, that you've satisfied those definitions if you're in a second relationship. And by the way, common law relationship, second relationship, mixed marriages, whether you like them or not, is a very, very common development in this country. Very, very common. So here's the situation, will versus no will. You know what? If I asked you a question and I said, the part of your estate that you don't get to spend, Brian, where do you want that to go?
That I don't get this.
That's right.
I don't want any of it to go where I don't want to go. I want to choose it all.
I understand that, but of the part of your estate that you don't get to spend, where would you like that to go? Any thoughts? Don't know that? Do you have a thought on that?
No.
Do you know what the assumption when I ask you that question is what? One, that you've got someone you want to leave it to. Two, that you're going to spend it. If you've got enough time, you're going to spend your last nickel with your last breath. That's the way you got the whole thing planned out. Now, most people don't have it planned out that way, unless, of course, you've got a Sicilian actuary, so you've got to look at some other way of doing that. So I said that you want to know what a Sicilian actuary is? Everybody knows? Okay. So a regular actuary can tell you the number of people that will pass away in any given year. The Sicilian actuary can give you names and addresses. That's the difference between the two. You've been to this point, Brian, said, I'm not sure where I want to go, but I want to go where I want it to go. Well, if you don't have a will, you don't get to choose that. It's chosen according to provincial laws. The province of Ontario, in this case, will determine where your stuff is going to go. The executive of your state, you can choose that if you want to. Otherwise, it's chosen by the court. It could be a court administrator. It could be someone who just goes up to the court and said, no other takers, I'm applying for the job. Might be someone interested in dealing with your estate that you would not like to, you don't want them to know anything about your estate. Black sheep of the family, an estranged relative, that could be that individual. In terms of the distribution of your assets, generally done in a timely manner. Of course, the timely is now differing now in Ontario because of the new laws that have come in force over the last year. But this is going to be delayed until at least the court appoints an executor. That rigmarole with dealing with all that bureaucracy can drag this thing out for a number of years. Maybe you don't care. but maybe the beneficiaries do. Guardians for your children, if you've got children, grandchildren. Guardians for your children, if you have adult children who are developmentally challenged. Like, who's going to be the guardian of those kids? Appointed by the court. So I'm not sure I want that to happen. I prefer it was my brother, my son taking care of my sister, but not the court, for God's sake. That's not what I wanted. But the will didn't, there was no other provision made for that. Taxation of your estate, minimized if it's done properly. High if assets aren't arranged properly. Extraordinarily high. And of course, if things have to be sold very quickly, and you've got junk and jewels, what gets sold first? What gets sold first? The jewels, and you're left with the junk. That's what happens. And the jewels get sold at a fraction of the dollar. The cost can also be pretty high. One of the reasons it can be high is that you are going to be paying for all these services, but if it's going to take a long, long time to settle that estate, that ticker just keeps going. It just keeps going on and on and on and on. You've got the increased potential for disputes. If you have to do it any other way. There could be a bonding requirement. I mean, one of the things that people talk about when you have a will, by the way, is that, oh, I have a will. I'm going to name my favorite daughter, Justine, as my executor. Yeah. She just picked up this dream job down in New Jersey. Can she be my executor? Sure she can. In the province of Ontario, she can be the executor as long as you post a bond equal to 2 times the value of the estate. Did you know that was going to happen? And that bond has to last as long as you're the executor. And if this executor, I can't settle the estate for a couple of years, that bond, who's going to pay for that? Where's the money going to come from for that? Did you even know that you had to do that? But that's the way it works in this province. Now, anybody here have minor children? So, more than 1? 2. My kids are now both over the age of majority. But you know, I'm not sure if you can relate to this, but if I had to leave, if I've got 2 kids and I wanted to just divvy up between half of them, both of them, each get half at the age of majority, not age of majority, but at some point in time. I'm thinking that if I'm not here, and my wife's not around, and my son is going to inherit at 18, I'm thinking that's a university education, down payment of a house, you know, tax-free savings account, good start in life. He's thinking Mayan Riviera vacation, 80-inch plasma TV, and a big party. At 18? Yeah. And where's my control? None. In my will, I may not have covered that off. Without a will, the court says, you're the age of majority, here's your share, now goodbye, we're done. And they're done too. In many cases, they're done too. I often ask people, I said, you know, I'm sitting down with families who've got adult children, and they said, or even minor children, and said, well, how do you feel about your children's ability to handle money? How do you feel about that? I asked Terry that question. He said, well, it depends which child you're talking about. Is that a legitimate response? Could be. Well, depends which child we're talking about. Might it make a difference? What's your name? Michael. Michael, might it make a difference about how much money we're talking about here? Yeah. So the issue is, I think I'm pretty comfortable with my son's ability to handle, not my daughter so much, I'm pretty comfortable with my son's ability to handle money. Like any amount? Any amount? Not just their salary, but this $3 million you're going to get, that your share, they can handle that, and that's not going to change them any more than handling a $20,000 checking account, or you know, their seg fund portfolio, or you know, their cash value life insurance, which is you start off when they were 3 years old, now it's got 40 grand inside. Could make a difference, right? Yeah. I talked to adult children, I'll get this a bit later, about powers of attorney. I asked the same question. I'm going to ask that same question again, because that can sometimes have an impact on the plans you actually make and the success of those plans. So we have multiple marriages with wills. As Terry said, you get married again, that will you've got might not be any good. You got blended families. The whole issue of common law spouses can be very, very problematic in most provinces. They've just changed the legislation this year in British Columbia. There's some modified legislation in Alberta. I'm going to tell you what the hard, cold facts are in the province of Ontario if it's not drawn up properly, if you die without a will. Here's what happens if you die without a will in Ontario. If you've only got a spouse, everything goes to the spouse. It does not, I don't care how well Terry and I are married, I don't care how badly she gets along with my in-laws, my parents aren't going to get a nickel. It is all going to go to her. They can fight and scream and it's all going to go to her. If I have a spouse and relatives, it's still all going to go to her. If I'm not married, it will all go to the children, equally. If I have a spouse and one child, the first $200,000 will go to the spouse, the rest is split equally. So in your situation, as an example, you didn't have a will, and you're married, and you've got 2 kids who are both minors. Your wife would get the first $200,000. I'm going to assume the house was in your name. It wasn't even in joint names. You'd have to take out a mortgage on the house because the court would come into play and say, let's make sure that the balance of that estate is not protected for these minor children because we're here to protect them from you. At 18, they get their share. Spouse and children, the first $200,000 goes to the spouse, and then 1/3 of the rest. The rest of it split, 1/3 of the rest she gets, the rest of it split between the kids. And of course, if you don't have a family, it doesn't mean it all goes. It goes to, there's a whole order of places it can actually go to. Parents, siblings, nephews, cousins, kissing cousins 3 times removed. That's actually what happens. But there's an important thing you got to remember about this. You've got 2 kids. You're a widow by that point in time, divorced, whatever else like that. And my son Chris over there needed some money. So I loaned him $50,000. Help him with a down payment house. I think he would get it back. He didn't write anything down. My son, I trust him. He gets us $50,000. 6 months from now, I get T-boned at the corner of Wellington and Commissioners. I'm gone. I don't have a will. And he's got the 2 of you as his brothers. You're going to split that will. That's going to split up equally 3 ways. He's going to get 1/3 of whatever's that estate, and he gets to pocket the 50 grand.
Not on my watch.
It's going to happen on your watch. But that is exactly what's going to happen. There was no document. There was no arrangement what's going to be happening. He gets the 50 plus he gets 1/3. How do you feel about that right about now?
Steaming.
Yeah, not very happy, right? You're laughing all the way to the bank. But that's what happens because it wasn't accounted for or accounted for properly. Was it an advance against the estate, or was it really, I'm going to give this to you, and you know what? He was my favorite.
That's not surprising, Sean.
Yeah. Now, intestacy. Let's talk about this thing about intestacy. It's either because you didn't have a will, or for some reason, the court said that will is not valid. We didn't like the signatures on it. There's a question about whether or not you were of sound mind and body. Were you under any pressure when you took that will? And the will gets contested. They throw the will out, and now you're intestate. And the 2 of us have had a lovely relationship together for 35 years. We took our vows on the beach someplace. Raised a family, 3 kids. We celebrate the anniversary of that little thing we had on the beach where we kind of read some vows to each other. We didn't want to be bothered with some stupid piece of paper, that technical bureaucratic garbage. We are free spirits. And 35 years later, I pop away, and I didn't have a will. What do you think you're going to get?
So a court portion divided, in addition to what the kids will get.
So what she says is she's going to get it according to what the court says. You're right. And the court says you're not going to get a nickel because we aren't legally married. You know, that piece of paper you didn't want to sign, I didn't think it was important either, and there's no will, it better be your legally married will, spouse. A common law spouse isn't entitled to anything. Nothing. You misunderstood me. No, I didn't say that. I said we made these vows together on the beach. didn't want a piece of paper. Everyone thought we were married. The kids think we were married. The family thinks you're married. You even took my name. The fact of the matter is, we were not legally married. We didn't have a civil union. Didn't go to the courthouse. Didn't go to a church. Nothing. We didn't do any of that stuff. So lived together for 35 years. Had a couple of kids. Shared everything. Some of the stuff was joint. You don't get a dime. You're thinking, I wasn't even working for the last 15 years. I was dependent on my income. That's okay. These are your 2 children. Go sue the estate, because that's your only recourse.
Can't you put a variance in under common law spouse?
I'll go through that.
You'll go through that.
Yeah. Not quite that simple. Not quite that simple. The problem is, before that, forget about the fact that spouse now means legally married in Ontario to collect under intestacy when there is no will, or a partial intestacy. In other words, you didn't account for everything in the will, so you do have assets in there that weren't accounted for, that part of it. In your common law, you had everything else except, that piece of the property. There was a miscalculation on the math about who gets what, the shares of a company, whatever else like that. Everything gets messed up. The spouse has no right in the property distribution. You have no say in how it gets divided. You have no say about whether or not my ne'er-do-well son over there, our son over there, terrible, the stuff he gets involved in. The minor shares on the court until the child gets 18 majority, then they get it. Party time, minor vacation, the 80 screen television, they can lease a sports, whatever they want to do. They want to burn through their estate in 6 months, fine. The spouse nor the heir has the right to determine the administrator. And spouse does mean legally married, to be entitled to a share. And you got to wait for the money. Everybody has to wait for the money, up to a year or longer. No ability to establish a testamentary trust for special needs beneficiaries. Income tax, probate planning opportunities, you forfeited all of those opportunities. You just gave it all up. So comparative rights of family upon demise, legally married spouse, you know what? They can take their share of the estate according to the terms of the will. They can say, you know what, I'm going to lay aside that, and I'm going to pretend, in Ontario you can say, I'm going to pretend we actually got divorced. And under divorce law, what would I get? You get an equalization payment of your net family property. They go through it as if it was a divorce, and you divide it up that way. You get your preferential share plus a percentage. But if I'm a common law spouse, there's no statute right to an equalization payment. It's not as if we're divorced. There's no statute right to property upon the spouse's demise. The Succession Law Reform Act says, yes, if I can claim I am a dependent, which I've got to demonstrate in court, she was dependent on me financially, then she does that. Her only possible route for property claims is to file a claim against the estate. You got to sue her kids, our kids, because it's all going to go to them. Kind of an awkward situation to be in, isn't it? That's the situation you're in. See, if I don't like the deal and I'm legally married, I've got all kinds of things I can do. But if I'm a common law person right there, the Succession Law Reform Act for support says, yes, defined as a dependent for the purpose of support. I have to prove dependency here. And the only possible route for a property claim is this quantum merit for unjust enrichment. And I can sue the estate for some other payment. That's the way it works.
How many years does that take?
It can take a long time, and it's going to cost some money. Hope you got some. You can't take it as an advance against the estate because you've got no claim to that. You've got to find your own way of trying to get that money back. It could take a long time. It could be an ugly situation. Hopefully, you and the kids have a good relationship. Get a great relationship with your daughter. Son, not so much. Actually, you have a good relationship with your daughter, but not her husband. And not a good relationship with the other one. It gets really messy. It's really complicated. Go to Walmart for $99. You can go get this thing taken care of. Do it on your own. Spend $500,000, even for a simple will. But not having anything or making sure it's not done properly can really cause a lot of problems that people don't think about. Because the definition of common law spouse does not extend to the division of an estate if that estate, in whole or in part, is deemed to be an intestate situation. Yes?
Well, it's a fair question. What happens if you had a couple kids and minors? You gotta wait till their age of majority and
What happens? The court appoints an administrator. You could file the claim. And you might have a chance there to file with the court So I'm the, well, we'll decide, the court will decide whether or not you're a fit parent, you can be the guardian, and you can clear that money for their sole benefit. And at 18, I hope you did a good job raising them by yourself. At 18, they each get their share. That's the deal. You've got no say in how they spend that money after the point in fact. Take your cash and they can just run. Done. Gone. I love my kids. 18, I wouldn't give them half of the estate. Not going to happen.
What would you do?
Can't do anything if I don't have a will.
No, if you don't want to give them half of your estate.
And then you put together a will with some documents and some instructions. And that's the other thing, with some detailed instructions to whoever's left there as the estate trustee that says, this is how I want it done. And that's the other issue that happens. If you want it done differently, you can lay all that out. You can lay it out in general terms in a will, and you can even let down some other terms, said, here's a sidebar situation to give you all the direction you want. I'll date it, I'll sign it, there it is. That's what I mean specifically about what I want you to do. And that can change. That's why I talked about the fact, the importance of stress testing your plans and solutions from part of time, because things will change. You're a lovely daughter, Nancy, but a great daughter right now, but this latest biker boyfriend you picked up, I'm not so sure about him. And you're just a soft touch. You're good with money, but I'll tell you what, your heart's bigger than your head sometimes, and it's all going to go to this biker boyfriend, Richard, over here. And he's... Once he's done all the upgrades on his Harley, boy, and had a good time with you for a weekend, he's gone too.
Gotta live in the moment.
I know. Yeah. He is. That's what happens. Yeah. So, will, what happens if you're caught in the middle? Because sometimes you get caught in the middle, and I alluded to this a couple of minutes ago. This is when you have what I call a partial intestacy. Well, I have a will. I've got a will. So everything should be okay, right? And they said, no, not necessarily. Well, how could that happen? It could happen. It could happen if you set up you've got a corporation, you're incorporated, and you pass away, and you've made a provision at some point in time because you retired or passed away to kind of take all that, the business you've got right now, and you roll it over into a holding company or investment company. You can do a rollover and not trigger any tax because you're not a doctor anymore, you're not a dentist. We have another business on the side. It's just holding all your investments. All your retained earnings are sitting in that company. So what am I going to do with all those assets if I don't get to spend them myself? If we don't get to spend them together? Well, we're going to name the kids as shareholders of that company. We'll do it that way, and they can do it that way. And you got 3 kids, and you don't do the math properly in terms of how many shares they've got, or how many shares they're supposed to have. Just an arithmetical error on the will. And the difference gets thrown into the residue that you're going to live to Aunt Sally or the next door neighbor, or you said, get split some other way. Well, that difference, because you did the math wrong, is part of an intestate situation, and it gets settled the old way, which means you don't get any part of that, and it could be a big number. So we had a situation in Ontario a few years back. There was a couple, years ago, went to Korea, and they loved Picasso. And they saw some artwork by this local young Korean guy. It was like Picasso. It was that type of impressionistic painting. They bought a piece of art. They spent like a few $1,000s on the art. Then they got it framed. By the time it was all done, they probably spent $8 or $10 grand on this thing. They were the laughing stock of their family and friends for all the money they put in this stupid piece of artwork. They had this whole will. There was some residue in the estate. They did some arithmetical errors because they said, okay, here's what happens. You get $100,000. I've got money in my account right now, this retained earnings, and in my company, you get $100,000, and you get $100,000, and you get $100,000, because that's all there'll be. Only your investment advisor was very good with that money, and now it's $1 million. So 100, 100, and 100. What about the other 700? It goes into the residue, and it was in that situation, gets divided up that way. So look at this piece of artwork. Everything got divided up, and the residue was going to go to someplace else. And no one wanted this ugly piece of art. They would have a fire burning in the back thing, this ugly little thing. They didn't want it. And someone who was going to get the residue said, what did they pay for that thing way back when? Oh, I don't know, $3,000 or $4,000. They got the thing framed, had to bring it back from Korea back to here. I don't even think I ever got it insured, but go check it out. Well, that Korean artist was pretty famous after a few years in Korea and Southeast Asia, that kind of stuff, made himself a lot of money. And then he died. And that piece of artwork was worth was over $2 million. The residue, the stuff that wasn't covered off, $2 million. And the fight was on. So you can have a partial intestacy. That can easily happen. It can happen with the shares of your business. The shares are split between the children, and one of them dies before the testator dies. So I leave shares to my children. 1, 2, 3. And one of you passes away before I do, and I've made no provision about how I deal with that share, the gift over. What happens? I haven't gone through all the math of that. That's part of an intestate situation. It'll get settled differently. That can happen. That can always happen. Okay? Deceased, you got to be legally married. You got to determine that first. Legally married. If you are intestate and you are legally married, if you're not legally married, forget about this thing. So you are legally married. It's an intestate situation. It's not covered off properly. The person says, how do I get that part of it was an intestate situation. How do I get that part of it? What's my share here? Do you remember the old slide that said you get the first $200,000 plus that percentage? They say, how much did you get on that split of the stuff that was in the will? Not in the will, that was intestate. It said, well, I got $150,000 that way. And it said, okay, you're entitled to another 50 to take it up to the 200. I'm already at 200. Well, then you get nothing. Then it just goes to the apportionment because everybody already got their excess. That's the way it works. They go back to that old set of rules and they deal with the excess exactly the same way. You can't double dip and said, it was 200 plus 200. This is the way it works. The balance is paid out according to the intestacy rules. Then you have do-it-yourself wills. Yep. Most people say, go get it done properly, but people don't get it done properly. I want to save the money, I'm in a rush, whatever else. And all kinds of reasons why they do it themselves, they change it themselves, and they said, I'll get it done properly. I'll write it all down right now, and I'll meet with the lawyer next week, next month, and it doesn't happen. So you're stuck with this. So there's a failure to name the executor or an alternate executor. Here's the scenario. What's your name? Richard. Richard, and can I call you John?
Sure.
Or Dr. John?
Either.
John? Okay.
Just don't call me late for supper.
Okay. So, we have Richard and John. And Richard doesn't like me so much. He wouldn't be my preferred choice. I'm not his preferred choice for an executor, or for a power of attorney for that matter. But you like John, so you can name him as the power of attorney and maybe I'm your executor. That's the only arrangement you made. You've got no problem with me. I'm your executor. In fact, I'm your power of attorney for property. You have a stroke. And you can't deal with yourself right now. John's got to step in now. He's going to take over.
He's going to pull a plug.
No, he's not going to pull the plug. You've had a stroke. You're going to be okay, but you're going to be in bad shape for a while. He's got to get in there and take care of all your affairs. John is involved in a bad car accident. He's in a coma. I got to step in, and I'm now John's power of attorney. Who's your power of attorney? No, he's not. It's me. You never wanted me in the mix. I suddenly become in the mix. I'm an executor situation. Same thing with the executor. I bought him the deal that I would be your executor. I didn't buy him the deal I would be his executor as well as yours. If you don't like the arrangement, or the executor says, I don't like the deal, you should go through the bouncing ball scenario about saying, well, who is your contingent? Who is your backup? Your contingent, your backup, in the event of two things happening. The incapacity of the individual to take on the job, the unwillingness to do the job. I did not sign up for that. I no longer want that responsibility. I'm not bound to take it on. I can quit up front, half through the process. What is the backup plan when your power of attorney or executor says, I'm done with this. I am not going to do this. What's your backup plan?
Are you obligated to be his executor? I mean, the court.
That's the way it works. That's the kind of the way it works in terms of detail. I'm not sure if anybody said, well, I'll tell you what, I want to be his. I don't want to, as his executor, I'm going to refuse to deal with his estate. I guess I could do that. I could try and do that.
But the court says you are obligated to do that?
The court right now, if I don't say otherwise, is I have the obligation until I try and unravel this mess and maybe leave the first gentleman sitting by himself. And I may not want the job. Or I may say, you know what, for that, I'm going to charge extra. like a lot extra. Let's say that these two people are running a business. They're both running businesses. They both got corporations. Active corporations. You know the low tax bracket type of corporation you've got, your active business income? Do you know that what you'll try and do, of course, with your active business income, you want to try and keep it below a certain threshold, right, to qualify for that low business tax bracket. So, David and Brian and I are all friends. David runs a business, and you run a business. And Brian has named David as his power of attorney. Something happens to them, and you're the power of attorney over his business. That's a connected company now. So in the Income Tax Act, CRA is within their rights to say, you know what we're doing? For the purposes of the $500,000 cap, it's the value of your business plus the value of your business. You're no longer in that small business bracket anymore. Well, that kind of messes things up for you, doesn't it? Messes things up for you too. So how are you going to sit there and fix that situation if you even can? Because the knee-jerk reaction is to say, you know what, then I don't want the job. I didn't do this so I'd lose, so it actually cost me money out of my pocket. I was in a 16% tax bracket, and now you're going to bump me up to the general rate? Really? As long as you have signing authority, as long as it's connected, and it's connected because you are running his business. You stepped in his shoes. That's the way that everybody looks at that arrangement. Did you know that? So I ask you, stress test the situation and find out whether or not you've got a backup for that. You may say, I don't want that job for that reason. Go get yourself somebody else, David. That's okay, right? You can find somebody else. You didn't like him anyways. You can get somebody else, right? You got to do that. So typical problems of this thing, by having to do it, and then do you do it all by yourself? You failed to name an executor, alternate executor. You failed to dispose of all of your assets. You didn't include everything. In fact, maybe you gifted more than you have. You know that Gran Torino that I got sitting in the garage? I don't mean any Gran Torino. I mean that Gran Torino. You know the one from the movie? Oh, that one. Clint Eastwood's agents call me every week about buying that. That thing's worth a lot of money. And the deal was, who's the car buff in the room? No car buffs in the room? Nobody? Nobody? Pretend. Can you do that for a second?
Oh, yeah.
I was going to leave the car. I was going to leave that Gran Torino to you. That was your inheritance. That was what you were going to get. Only I sold that sucker. And that was what you were going to get. And it was your fair share. What do you get now? I get to more than I have. I don't have it anymore. You get cut out because I've not made any provisions for rebalancing the estate so that you get anything. Because I made it very, very specific. I got 3 properties. I've got a condo. I've got my house here in London. I've got the lake property over at Grand Bend, and I got a property down in Florida. Give or take a few $1,000s. It's comparable values. And even though the values aren't exactly the same, really, you really want the Grand Bend property, right? And you'd rather have the place downtown here right now, and somebody else. So you divide up that way. Only if one of them gets sold ahead of time, sold and the money, sold or spent or whatever else like that, then it's gone. It's not in there. It's the failure to appreciate the rights of the spouse's independence, which they've got. They can contest the will, do whatever else like that. Improper wording can mess you up, or just invalid provisions. And there's lots of them that can actually occur. That's why I say be careful. Double read that document the lawyer brought up to make sure that when he did the boilerplate template and copied something over, he didn't copy something over that doesn't apply to you. Will's not up to date. Significant change in the client's personal or financial situation. The change in the nature or the size of assets, either they've gone up a lot in value or they've gone down a lot of value. The loss or addition of beneficiaries, the marital status changes we talked about. Divorce doesn't necessarily invalidate the will. The will is read as if the divorced person is not part of it anymore. But you have all kinds of situations where you have people that are separated. You know what, we didn't do the paper up front. I don't like you, I hate you, whatever else of that done. I move in right here, and we're living together for a while. We live together for 4 or 5 years and never get legally divorced from you. And what happens on death is that I've got 2 spouses. I do. And do I have a will or something that deals with how that's going to happen? A change in health, a change in residence. The will has read in the jurisdiction that you are in. Your powers of attorney are read in the jurisdiction you are in at the time, so that they have to read the document, not where you drew it up. It's got to be valid in that other location as well. Or just a change in the law. So you can have too little detail in a will, that's always possible. But you can have a situation, by the way, where you haven't really given away any powers. The powers aren't right. Powers including tax-oriented clauses. I'm going to give my executor the ability to listen to my financial advisors about taking advantage of things, but there was no license to do that. I'm going to make a provision because I want the cottage to stay in the family. I want it to, but I'm not sure they can afford the upkeep. If you didn't give the trustees, the executor, any power to set aside any money, how do you make sure that the maintenance of the cottage will be kept up for any length of time at all?
Insurance.
But if you didn't have that, that's right. But if you didn't have that, that's the issue, right? The legal interpretation could be at odds with the true intentions. It's not really what I meant, but that's the way you wrote it out. Or the disposition of personal property. So I'm in a situation right now where I've been named the power of attorney. And I'm measuring your power of attorney, I'm doing it for you. You've got 3 major assets. You've got an RRSP with a named beneficiary, and you named Jonathan as your beneficiary for that. You've got a condo in Florida, and you got that. You got the condo. You happy with that? You're okay. You get the condo, and I got the house right here with a little bit of cash in the bank account. We just kind of divided up that way. But you're incapacitated. I'm your power of attorney. And there aren't enough liquid dollars now to take care of that and to make the provision. I didn't listen to the appointment about getting together and buying any kind of stupid, expensive insurance. I didn't do that, or I put it off. So now I've got to liquidate an asset. Which one do I liquidate? But I got no direction as to which one I'm supposed to liquidate. I'm going to liquidate the one that's going to cause me the least grief, that's going to retain most of the value of the estate. I'm going to do the smart thing here, and the smart thing may not be the right thing. I may say what I should do is take a chunk out of each one and say, that's too much of a hassle factor. I'm just going to drain one of these accounts, which means one of them is going to be affected, right? So if I've got to liquidate, in what order do I liquidate it? And what are the delivery costs in case I've got to transfer? Delivery could be the property transfer values, transferring property, what's going to happen here? Integration issue wills, of course, are non-will based transfers. In Ontario, we're blessed because we can actually have 2 wills. 2 wills. One for all your personal stuff. You could have a separate will that deals with the shares of your company. It doesn't have to go through probate. A separate will that does that. But do the 2 wills, do they talk to each other to make sure there's no problems there? You're a dentist. You got your dental practice, you got a corporation over there, and then you got something else going on someplace else. So another little practice you got going. In your dental practice, you're by yourself. There's other thing you've got going on the side, whether you're in the medical equipment or dental equipment or whatever else. Side business, you got 2 or 3 shareholders. First off, no buy-sell agreement. So you haven't figured out how you're going to divide up the shares of that business. 2, you got an agreement, and there's no money to actually pay for it when it happens. And 3, you were smart enough. You got the agreement. But when you got the agreement done, you had it done with a big law firm in Toronto, because that's where your 2 partners were from, a big Bay Street lawyer. And your down-home lawyer here who did your real estate deal and did your will and that kind of stuff back here in London, your old university buddy, he didn't even know what was happening. And those lawyers don't talk to each other. One doesn't even know the other one exists. And it's very, very conceivable that the terms and conditions of the will are at odds with the terms and conditions of the business agreement. The business agreement, some of it, details may have been covered off in the will, but it's different. You're giving away stuff you don't have. The will says, I want it to go to my kids equally. The buy-sell agreement says, no, that's not going to happen. It's going to be divided up this way, or in this percentage-wise. Very, very different way. We're dealing with people here that have a pretty strong insurance background. And you may do all your business with these people that are here. You may do with other people here. And I find sometimes that when people are trying to decide how to deal with things that are insurance-based, you could have a beneficiary, is that, well, you always have a named beneficiary because you want to skip probate. And, of course, you want to worry about estate creditor protection. That's the 2 major drivers for that. Much better than having a will. You don't get either one of those 2 things. But there's really all these considerations you've got to look at. Ongoing control of the asset, because you want to control how and when they're going to spend that money. creditor protection from the beneficiaries, their creditor issues, income splitting opportunities. They're going to be more limited now in the next couple of years, but you still got that for a period of time. And what about disabled support maintenance, if that's an issue you've got? You've got that issue with one of your children, perhaps a grandchild, whatever else like that, because you got to provide care for them for not as long as you live, but for as long as they live. Well, a will can take care of those things, but this is what you give up. But putting that money into an insurance trust allows you to take advantage of all of these things. So naming a beneficiary, I got a named beneficiary, everything's taken care of. That may actually not be the best route, depending on what you want how comfortable you are with the beneficiary's ability to handle money, what their situation is, what the changes are. This can give you far better control and can still take care of these two issues. Again, I'm not saying go this way for everything. I'm saying stress test the deal you've got right now in your own situation, and you have some wiggle room to perhaps make some changes from time to time. There are lots of challenges to creating a valid testamentary trust. This is a trust you set up after you pass away because you want someone to be in charge of what happens not only to minor children, but what happens to spendthrift children. Really, the ones who just can't hold a nickel between their fingers for only 5 or 6 minutes. What happens to them? Well, if the ownership is not insured, life insured, they're not the same individual, you can't use that money to fund a testamentary trust. You have a group insurance plan, you want to do it that way, where you got on the life of dependent, that can't be used to fund a trust. You can't use that process that way. You've got a corporation that's the owner on a shareholder's life, that money can't be used to go into a testamentary trust. A wife owning a policy on a husband's life, no, that doesn't work. A parent owning on a child's life, that doesn't work. Jointly owned policy, like a lot of this stuff becomes problematic. So there may be very legitimate reasons for doing these things. Only if you want to couple these solutions with that strategy, you're going to run into challenges. You're going to run into problems. The choice of the executor and the power of attorney. We talked about some of the problems and surprises that occur, but you've got to look at competency and ability. It's one thing for me to name you as my power of attorney for property. You know my bank accounts? I'm not so sure you're the right guy to run my business. But I didn't specify that. Maybe I want 2 different powers of attorney for that issue. So what is your level of stability? What's your financial situation? What's your set of family? Can I trust you? In fact, can you be objective in the eyes of the other beneficiaries? Because sometimes a sibling, just in that ugly situation, I'm always going to be the 14-year-old brother who shoved you down the stairs at some point in time. I'm never going to be forgiven that issue. There's always this bias against me. How objective can I be? What is my willingness, not just now, but down the road if this takes a long time to do that job? What's my accessibility? Is it going to be easy? I know she's done a great job. She's in New Jersey, for God's sakes. That's a lot of traveling back and forth. And what are the contingents? What are the backup plans? If it's not you, then who? Disposition of personal property, itemize specific items. Again, a lot of people do it. There's certain items you want to do. I'm not saying put together a list of everything you want to have, but you got certain things you know could be problematic or special. At least write that down. Either put it in the will, put it in a codicil, write down the items, said, this is how I want it done. So there's no fighting. I want it done this way. And have a scheme for the residue of the balance. Who's going to get the residue? And there's going to be residue because you didn't cover off everything. How are they going to get it? How do you handle disputes? Is it binding or non-binding memorandum going to wrap up? But have you taken care of that paperwork? Have you done that type of organization? Have you sat down as couples or with families and had the discussion?
Excuse me?
Yes?
What is a binding memorandum? What does that mean?
Well, you could have a binding or non-binding memorandum that said, this is the way it's going to work. So you could say, daughter number 1 is going to be the trustee over her brother's stuff. Because he's just not good with money. I know he's older. I know he's 48 years old and she's 42. But there's going to be a binding deal that says, this is the way this is going to work.
If you split it equally between your children, then you don't get into that.
That's a good question. So let's talk about that for a second right now, okay? So how many children, do you have children?
3 children.
You got 3 kids. So typically what I ask people, I said, you know what, of the part that you don't get to spend, your estate you don't get to spend, where do you want that to go? And you say, I want that to go to my kids. We'll lay aside the charity and stuff like that, to my children. And I say, okay, and how is that going to be divided up between the 3 of them? And you will typically say,
Divided
equally,
evenly.
equally. So I always ask the question, that's a knee-jerk answer. I love my children equally. That's the right thing to do. My question is simply this. Is it more important for you to treat your children equally, or is it more important that they be felt they were dealt with fairly? Because equal and fair are not the same thing.
Can you give an example?
Yes, I can. I'll give you a couple examples. I have, you got 3 children. I don't know anything about your family. You got 3 kids. One of them is just finished off his residency. He's going to be an orthopedic surgeon, going to make himself a pile of money. Second one is an accountant. Just landed a job as a vice president of an accountant, make himself a very comfortable 6-figure income. Third one got hit by a car at age 15, is a little slow. Has attention deficit syndrome, can't really pay attention. Functional, quite functional, but has got a decent, not a great job, but a decent job, that kind of stuff. You said, you know what, I've got concerns about child number 3. Now, I definitely want to give something to the first 2 children. I want to make special provisions for the 3rd child. I think that's the fair thing to do. It isn't equal, but the other 2 kids may say, better you than me. Maybe that child didn't have a car accident. Maybe that child's got Down syndrome. And you said, I have to make special provisions for that child, for my child. Because if I don't do it, it's going to be on your brother and sister to take care of it because they don't want to. That's fair. Is it equal? I've got 2 children. You got 3 children. 2 of them are really good at handling money, and the 3rd one is not. Is not now, never will be. So equally said, I'll give them each a 3rd. You get a check, and you get a check, and I have a trustee, Barbara here, and you get a checkbook. I know you're not going to fritter away the money, but you get to waste that inheritance 1 month at a time. Equal. The terms and conditions are a little bit different, and I make them binding. I can set up a trust that's binding. There's ways I can do that very simply to make sure that you can't frustrate, not you, but the kids can't frustrate the inability to do that. Notwithstanding the fact they're 45 years of age and want their hands in their money. Yes?
How long do you have to try and maintain control? I mean, at some point, if you have 3 functioning children, I mean, why do you have to make those kinds of decisions? I mean, can you not just say equally, you know, you get your share and then...
You can. Yeah, you can. Yeah. But some children just can't cope. Some can't. Some can't. They've never been good with money, aren't good with money right now. One bad relationship with the other, one common law relationship with the other. You got to protect them not only from their latest common law spouse relationship, you got to protect them from themselves. So the money doesn't go to drugs and alcohol and foolishly, no retirement plan, nothing. I said, I'm doing this for you. You've got a job, but whatever I'm going to do to you is because I love you. It's not because, if I give it to you in your hands, it's gone. And you can say, tough. I said, but that is, I'm not sure that's really the thing I want to do as a parent, to take care of you. Yeah, and a lot of parents will take that position, yes.
So what if one of the 3 children is not as functioning as, not as great a future as the other, surgeon and whatever.
Mm-hmm.
So with the 3rd one, if you formed a corporation and built a company for that 3rd child, then with a secondary will, that child will be protected in the interests of that company that's been formed with that child.
You could, provide that child had the capability, the competency level to run that company,
Right.
or that you set up a structure where you had trustees or owners or whoever else that were directing that company to make sure they couldn't do that. So as long as you built in some parameters around that and some safeguards, that might be a provision. Another provision would be, I want them treated equally because they're all going to see the will. Well, I could use something like a life insurance policy, and I could pass something outside the estate that could take care of that child separately. So I'm not rubbing it in anyone's faces, but I make a provision to take care of that in some other way. Right? I can do that.
Peter?
Yes.
One of the situations I see a lot of with people is that they're concerned that their children's marriages aren't going to last.
Yes.
What happens to the inheritance if that marriage breaks up? Let's say that the children have already gotten the money.
Yeah.
What happens if the marriage breaks up?
Well, inheritances generally are not subject to a division of property if the relationship falls apart, unless you commingle those assets into a joint account. In other words, if I take my share of my inheritance, and Barbara and I do not get along anymore, and I have that money after I get the check, and I put it into our joint account, it's up for grabs. I keep it in my account, it's not.
Even though you've been married for
Doesn't matter,
15 years.
because there's an inheritance. And I can even specify in the will saying, this is inheritance. It is not to be part of a division of property. Because I know that's on the rocks now, and that they'll honor it, and it will never be. She can get as mad as she wants, hire whatever lawyer she wants, she'll never get that asset class. I can invest it, do whatever else I want to do that. I take that money, and I use it to pay down the mortgage on our jointly owned home, our principal residence. It's gone. So I can't commingle the money. And commingling means I can't mix it up with the stuff we have together. If I keep it separate, I'm always okay. I can choose to give her money whenever I want, but the separate stuff, as long as it's separate, is always going to be mine. That's part of my protection. That's a simple way of doing it. Setting up trusts and family trusts is another way of doing it. If you're always worried about blood is thicker than water and the in-laws are never going to get a dime, that's the way I want it. That way, you can set up a trust and you can handle it that way too. But I would do that with a larger estate. Yes?
You mentioned that if she inherits money, you won't be part of a division of property after the divorce. What about the growth on that money, though? If she inherits $1 million from the married.
If you set it up properly, you can put that provision in there. Yes, if that asset, whatever it grows to, boom, that's separate. Typically, that.
Rarely, if ever, see that
Pardon me?
in a will. I rarely.
Yeah,
ever
but I have seen that in wills recently.
That has to be specified.
Yeah, you got to lay it all out.
So it's not up to the recipient, it's up to
Yeah, it's up. No, the recipient has no say over that. It has to be drawn up. This is the term of the deal. And if you talk about a significant amount of money, then setting up a trust actually gives you that ultimate amount of protection. Then you said the trust is only for these people, and that can be really discretionary as a trustee. And said, okay, I know the two of you aren't getting along right now, or you're not going to get along. I'm going to hold off on that money right now. I'm going to give you just enough money to get by, but I'm going to make sure she never gets a dime of it. The asset she can never claim because you don't own it. You're a beneficiary of the trust. And only if that trust is unwound or distributed, you ever get it. You're an income beneficiary. Capital is up to me. It's my discretion. I don't like the way you combed your hair. Don't like the shirt you're wearing. You're not going to get it. And I can make it that way just to protect you from marital discord. I can do that.
Gifting doesn't constitute mingling, or
No?
gifting, you can gift it to your spouse and it's never,
That's right.
it doesn't constitute.
Yeah.
Then, why did you mention there the binding versus non-binding memorandum? What's the difference?
Well, I could have a situation example. Where I say that, frankly, I just don't like the way you handle money, and so I'm going to set up a trust or an income stream for you for the next 15 or 20 years. And you decide that was being really egregious, irresponsible at age 45, and you're still stuck with this thing at 54. You said, I'm done with this thing. I'm going to go to court, and I'm going to appeal that decision. I've got all ruled. I want that value commuted, and I want all the money now. Take your best shot, because the provision I put in there in my binding memorandum is this. You get the money as long as you live, and the residue is going to go to the local hospital. Whatever you don't get to spend is going to go to the hospital. We got another beneficiary in there that stands, you can't commute that value because you now disadvantaged another beneficiary. So if you want to play that game, you can play that with me. And with a lot of people who got wealth said, I don't mind donating something to the Royal Vic or some other hospital, the Cancer Foundation, Heart and Stroke Foundation. You got something philanthropic, there's a way of tying those two things together if you think that those games can be played at some point in time. You can protect that. Binding memoranda. You do that, you're never going to get a dime. You do this thing, you can put in a memorandum like that that says this is the way it's going to work. And you do it's like a poison pill clause. You try to do something differently, this is what's going to happen next. And the trustees just execute it. It's done.
Can I just say
Yes.
something about that? Sorry, is that with regards to a trust, in Canada, if you only have one beneficiary on the trust, if all beneficiaries, meaning if just the one, agrees to disband the trust, they have the right to disband
They got the right to that.
trust.
Yes, they do.
They do. So if you want to protect the money from a spendthrift and you set up a trust and they're the only beneficiary, then they can dissolve the trust as long as they're of sound mind. So you need to have someone that's got enough understanding about what happens to say the beneficiary is the spendthrift, and as you said,
The residue,
the
capital ever
revenue
left out,
goes to
whoever.
Health Sciences or St. Joe's or the psych or whatever have you, it goes there. Now you got two beneficiaries and the second beneficiary can't sign off on dissolving the trust, so you're absolutely guaranteed that
Yeah.
the spendthrift will be able to keep the money. So there's some awesome ways to protect family members from themselves and from others.
Yeah.
Spouses, everything.
Joint tenancies are often misunderstood, and sometimes they're written incorrectly as well. I'm not advocating one over the other, but there is a difference between tenancy in common and right of survivorship. Tenancy in common, we used to own an equal interest in it, but that's it. With the joint tenancy situation, with a tenancy in common, you and I can own an equal share or an unequal share, not a problem. When I pass away, my share goes to whoever I want it to go. When something happens to you, your share goes to whoever you want it to go. This works great in second marriages, that kind of stuff. You do it that way, tenancy in common. Joint tenancy, the deal is, when I pass away, my share goes to you. When you pass away, your share comes to me. It's right of survivorship. That's what the two are. So there's a reason why you can do that. Tenancy in common they can be a specified share, it can be equal or unequal. Joint is I've got an undivided ownership in the whole thing. It's generally decided to be, that's an equal deal in the whole property. And this is the problem, that's the way it actually works. So if I go into a joint ownership situation with my family home, with my aging mother, and I run into problems, then because I have a joint ownership interest in that house, and the creditors go after me, they can sell the house and throw my mother out on the street, unless you can come up with a mortgage to pay off the creditors. So a growing trend of parents and adult children doing this. Typically it's a widowed parent. It's seen as easier than a power of attorney. The fact of the matter is there's no advantage here by doing it that way. Could be a big downside as well. The scheme is that you want to avoid or reduce probate fees and avoid administration and will costs. You may or may not do that, but you're putting that whole property in jeopardy. The transfer triggers an immediate tax consequence. I go into joint ownership with the family cottage because I want to skip probate. I'm deemed to have sold my whatever share I transfer to them. If I said I want you to be an equal partner of that, I've sold half my cottage. I've sold it. I bought this thing for $100,000 and now it's worth $5,000. I have sold my half interest. I will trigger capital gains tax today on that interest. This property is at risk if the joint owner gets into trouble as well in terms of financial, creditor, including the spouse of the owner. It becomes part of the division of the property. This isn't a gift situation. That's not what happens. And there can be a lot of abuse by the new joint owner. And the issue too is that I do this with one child as a joint owner of my bank accounts, and the other kids say, well, what was the deal there on that sort of thing? I thought you did that for convenience. And now that mom is gone, you're pocketing the whole money, and then you're still going to get your share of the whole estate. Most of it sitting outside the estate. I'm not sure that was really fair. Taking back the interest is really tough once you set it up this way, so your own situation, and perhaps your parents, can be very, very problematic. I know you avoid probate, but you certainly miss income splitting opportunities after death. And you do increase your estate settlement costs and time throughout the entire process. Basic issue is that there is no plan, or there's no documentation. There's no advance directives, no letter of supplemental instruction. So we're in a situation where caregiving right now, and with my mother-in-law who's terminal. But everything is written down. Whether she wants a funeral or doesn't want a funeral. Who's going, who's not going. What kind of sandwiches are we serving, what kind of, like everything is worked out. We have a listing of every single advisor. The accountant's name and contract, that kind of stuff, blah, 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 blah. It works. What about digital assets? You've got computers, stuff stuck on password protected for all kinds of things. Do you know what those numbers are? And you may not need to know what they are right now, but there better be a central place where the executor can get at that stuff after the fact and retrieve that information and deal with it. I can't remember my own passwords. Can you imagine if somebody step in right now and try and find this stuff? And resetting it sometimes can be a really big issue. So that's a letter of supplemental instructions. People often set up powers of attorney for health care, but don't really give details. The devil is in the details sometimes in terms of what specifically is involved here. And healthcare is not about pulling the plug. Healthcare is about quality of life. So if mom says, you know what, every month I still got my hair done, the power of attorney for healthcare says I get to make that call. She still wants to go to the theater tickets, and she still can go. We're spending that money to maintain her lifestyle. We're going to do that. Even though I'm not the power of attorney for property finances, healthcare includes lifestyle. It's everything. Where I'm going to live, how I'm going to live, all that kind of stuff. But what do the directives say in terms of what can be done, what cannot be done? How specific is that information? Because the more detail you give me, the better it's going to be. Think of me about being your financial doctor. Prescription without diagnosis is malpractice. And I don't want to be in that situation as your financial advisor. So we've covered off wills, integration, the importance of doing that, liquidity, debt, the difference perhaps between equal versus a fair distribution, the unfettered use of joint tenancies, and the real importance of actually looking at reviewing the whole plan and reviewing the plans and solutions to make sure they continue to do the job they were designed to do when you first set them up. No matter how much we have, it's our chance, it's our choice to say how our assets are being divided up when we're no longer around, and how our assets be divided up while we are still alive. When my dad died, a couple years after she died, my mom was downsizing the house. She started dividing up her estate then. First, she started selling all the stuff to give us the cash. She thought that would be easier. We were more interested in the stuff because of the sentimental value. We didn't care about the dollar value attached to it. But it gets lost sometimes that way, to do it that way. And giving things away while people are alive, as people are living longer and longer and longer, is a reality. They're living their 80s and 90s. You know what? When you're 60, you're saying, I can't afford to retire, I won't have enough money. Then you do all the crazy things in your bucket list, and you're in your mid-70s, I'm going to run out of money. I'm going to run out of money. Then you're 84 years old and said, I've got all this money, I'm never going to spend it. 2 cars down to 1 car, one spouse died, lost my driver's license, I've got duct tape around the kettle. I know that all the channels don't work on the TV, but I'm so confused about buying these new LED things. Forget it. I can be dead tomorrow. I don't even buy green bananas anymore. You know, that's the stage they're at. They don't want to spend the money, right? And then they start giving it away at that point in time. Well, what is the methodology for being able to do that in an organized bidder? So get organized. Get organized, write it down. When it's documented, you can see if it's clear. You can have it interpreted by yourself, with your family, with your advisors to make sure it works. Not just today, but periodically throughout your lifetime. So as tax changes occur, change in legislation occurs, strategies work, products change, that you know that you're always going to be up to date, and what you want to have happen will happen, and that your dreams, in fact, will come true. Thank you very much.
Situation. My mom passed away, and I'm an only child, and my dad's, worried about probate. So, what's the best time attack you should do to leave me the house and money? This is his question.
Sometimes probate's not a bad deal, unless if you're the only child, or
Yes.
yeah. Sometimes probate's is not necessarily a bad arrangement. So some people are so focused on the probate issue and they don't forget about looking at the big picture. It is 1.5%, but I shy away from the idea of saying doing a joint ownership on something like that. So if it's what's the property we're looking at?
His house.
His house. So here's the issue. You are a homeowner,
Yes.
and he's a homeowner.
Yes.
Once you become a joint owner on his property, you'll have to decide when you sell one of those properties, which one is your principal residence. And the other one is going to be subject to a capital gain. Trade that off against the 1.5% probate tax. If you do this right now and he doesn't die for another 5 or 6 or 10 years, and that value suddenly goes up in big way, the capital gains on the disposition of one of those properties is going to be many times more than the probate tax you'll ever pay. So just a quick answer. I did get asked before the group whether I'd cover off any type of U.S. issues. So just a very, very quick thing about that cottage, the family cottage, which is your condo or your property down in Florida as an example. Make sure that the wills you've got, estate planning, covers off that property in the other jurisdiction. And keep in mind something, by the way, is that the way things are taxed here and there can be very, very different. So in Canada, I'm with my good buddy right now. We're golfers. So meet my golfing friend right here. My best friend. We're golfing buddies. Been golfing for 20 years together. And 5 years ago, this guy, idiot, on a rainy day, runs off one day by himself, doesn't tell me what he's doing. I have supper all arranged because I did it back at the condo, and he says, I'm really not hungry. I had something to eat, something to drink. And where did you go? Just someplace. He's embarrassed to tell me he went to one of those little timeshare places or whatever else like that, and he bought himself a condo, a row house, on the golf course. That's what he did. And he bought it for $50,000. And I laugh at him for the next 8 years why he does that. Now, even after everything's gone down and come back up again, it's now worth 250. And you said, who's laughing now? This is the place we stay in. And you say, by the way, Peter, there's an end unit that's available right now. If you buy it right now, you should. It's worth the same amount as mine. It's an end unit, but I fixed mine up. He didn't fix his up. Fix it. I don't care if you sit on it for a year or nothing. A big developer's coming in here. He's going to buy all these things out. You're going to double in price in the next 2 years. It's what's going to happen. And I look at all the evidence that it probably will happen. So I buy the place for $200,000, right? He bought, so it's a value the same as his. We go to celebrate the country at the Golfing Country Club. We're killed tragically in a golf cart accident on the way back to the clubhouse. Terrible. Too many pops. Does he have a capital gains problem in Canada? Do you know? He does. He bought the place for $50,000, is now with $200,000. In Canada, he has a $150,000 gain. He has a capital gains problem he has to declare that gain on his income tax return. Do I? I just bought the place today. Same value, no problem. But in the United States, we have exactly the same estate tax problem. It's $200,000. It's got nothing to do with the increase in value. It has to do with the actual value of the property. Notwithstanding the fact he's owned the place for 10 years, I've owned it for 10 hours. We have exactly the same problem that we have to now sort through and figure out if there are any exemptions, breaks, whatever else like that, that can skip that type of a deal. So that could be a problem. And a lot of the methodology, ways that people used in the past to take care of those things don't work anymore. Well, put it in the corporation. Go ahead and do that. You better have other stuff in the corporation because the single-use corporations don't work anymore. They haven't for 9 years. And if you're putting in a corporation and you're using that for your own property, I'm sure your accountant's declaring that as a shareholder benefit every year. You are paying a shareholder benefit. You are paying taxes on the use of that property on your own cottage. But you better be doing that or you're going to be in trouble with the Revenue Canada. Forget about what's going on in the United States. So all that kind of stuff happens. And then you don't know if your will actually cover that off. Does the executor have the right to do that sort of thing? And the executor is personally liable for the tax. So the next time they want to go to Disney World or golfing, the thing that you haven't paid that tax, they've got his name and number or her name and number. And there's nothing like a multi-trillion-dollar debt to beef up enforcement of rules that have been around for 50 years.
Wow. Okay, let's have
Okay.
a couple more questions.
Yes?
Does it make sense to have a will in every country where you have property?
It may make sense. Again, you stress test it because sometimes the will you've got here is operable. It'll actually work in that country. In other cases, you may find you want to do a simple will just to deal with that particular property, and you may want an executor that's comfortable with that particular jurisdiction, depending on what you're doing. So I can't give you a black and white answer on that. It kind of depends on which country you're actually talking about, whether or not they actually honor those types of deals. If you're dealing with a country that is under common law versus many European countries that work under civil code, very, very different operations in terms of work. Quebec and Ontario are very different. Ontario is common law, Quebec is civil code. Many European countries operate the same way. So the stress testing will actually tell you whether or not it makes sense to do that. And it doesn't have to be an overly expensive thing because in many European countries, as an example, you do it with a notary. It's a very simple process to deal with that one little asset class. And that could, in the long term, really simplify the affairs.
Okay, John, and then,
Yeah.
then,
Question about the home ownership that was raised. If she owns her own home and has a joint ownership with her father for the other home.
Yeah.
If she's living in her own home and declares that as a principal residence, when she sells that as her principal residence, could she then not move into the joint home and that becomes her principal residence for future?
Yes, it does. But for the period of time that you own both properties, then the increase in value during that time where it wasn't your principal residence will be subject to a capital gain. Then you go through a change of use at that point in time. But you can't skip out on that capital gain during that period of time.
You can run, but you can't.
Yeah, you can't hide.